Awesome. So welcome everybody. This is your first time meeting Melissa. For some of you, you've met her in person. I know, Austin, you've met her at MetaMind, and some of you at TNC. So Melissa is awesome. So in addition to being so like positive and bubbly and just such positive energy, she's also super smart, super experienced in business law and IP specifically, and does like holistic business law that really captures everything that's important to your business, and in both protecting what you're creating and leveraging it in a way to expand what you're doing. So she's going to talk about a lot of that with IP, and I know that throughout the last couple of years, I've had a lot of questions in Next, both in the Facebook group and on WhatsApp, and personally, specifically about laws and contracts and what to do in different situations, and a lot of that kind of already came out on some of the Facebook threads that we started with Melissa. So today I'm really excited to bring her in for this hangout, to have her kind of present whatever content she wanted to do, and to deal with a lot of your fun legal and contract and IP questions. So welcome, Melissa.
Perfect. Yeah, thank you. So I wanted to start by just seeing if there were specific questions. Can everyone hear me?
Yes.
Yes. Yep.
So like Dimitri just said, I work with contracts in the transactional world and have that high view of business, taking kind of everything into consideration. What are all of your assets, right? Like your product, and then also the intangible assets or the intellectual property. How can you leverage those assets? How can you create joint ventures both within your industry, and I think that Yannick had been talking about IP cross industries, which is huge. That's a huge potential source of revenue. And then I've had some specific questions about agreements. I actually had a chance to look at a few, looking at a master services agreement right now, and just wanted to know if you had specific questions, maybe I could hit those directly and not just talk theoretically. Does that sound good?
Sounds great.
I have a couple specific questions.
Yeah,
we have a couple of loops questions, which are kind of big picture, so I can ask those in a second. Before I go to those, because I know that'll probably be a longer, bigger picture conversation. Does anybody have any like very specific questions? And I know the answer is yes, so kind of bring them out. This is a great opportunity to talk.
I do. Let me jump in.
Yeah.
Yeah. Go ahead.
Hey, Melissa. Nice to meet you.
Hi. Is that Anthony?
This is Anthony.
Oh.
So, big thing that we think about a lot are related to NDAs and non-competes. So that's a common thing that people request is non-competes, and we do not sign non-competes. So first question is, other than like an NDA, is there any other good alternatives to a non-compete out there that we could use instead of a non-compete? I'm always kind of looking for.
Yeah. So non-competes. So I'm gonna take one slight step back. A lot of people say, like, no one reads an NDA anyway. I don't think that's true, but I'm a lawyer. So the purpose of an NDA, it's a non-disclosure agreement. So that's that you don't disclose, right? You don't disclose whatever it is that you agree not to disclose. It could be that you're even thinking about being in a business relationship in the first place, right? It could be the terms of your agreement. And typically the NDA, so that's like your first introduction usually. Like, this is kind of more information about what we're working on, but we don't want you to tell other people, especially our competitors, or if you are a competitor, we don't want you to use this information. And that the purpose of putting it on paper, especially if you're going to talk to somebody who's a potential competitor, is that you make a paper trail.
Right.
Right. So, right. Okay. So if you don't have that, I've worked with clients who downloaded something from the internet and used it, but it really didn't have any meaningful information in it. So it didn't do them any good.
Gotcha.
So you want to make sure that you're pretty specific around the scope. And typically in an NDA, and let me open up the one that I think you forwarded me one. Typically with an NDA, it'll start out, I call it like, like a boxing match, like in this corner they have this person and in that corner is that person, and it kind of just sets up who each other is. And that's really for the trier of fact way down the line if this were to ever go into court or jury, so that everybody understands, okay, before they started, this one was doing this business and this one was doing this business. So if you didn't put in writing where you were concerned of a potential overlap, it's almost like bad on you. Does that make sense?
Yes.
Any questions?
I think with all the NDAs we've signed, we've never written in the NDA the scope of the business. It's just it kind of just says whatever you discuss that should not be disclosed to other people. So you're saying
that's a really, really general one. I like to make it more specific.
Okay.
Those are the ones that really have the teeth in them.
Yeah.
Because otherwise, it's sort of like if you have a general NDA that says anything that you discuss you can't share, that means that technically you should follow up every conversation with an email that says everything that you talked about, that has on the top of it the words confidential information or something like that, just so everyone's on notice.
Yeah. Okay. Another question.
So the other thing with the NDA, so that's the non-disclosure agreement. Sometimes people also talk about that as a confidentiality agreement. They're slightly different.
Okay. When would you use a confidentiality agreement instead of an NDA? Can't hear you. I think you might have muted yourself.
Melissa, I think you're muted, or we can't hear you. It doesn't look like you're muted, but it says we can't hear you. And now you're frozen. Okay, well, I try to get Melissa back. Guys, just keep piling questions into the side chat, and I'll field them. Oh, there she is. Still can't hear you. I can see you. Give me 1 second. Let's try to dial in your cell.
Hey.
Go.
Hello?
Yes, awesome. You're back.
Okay. I believe the question was when do you use a non-disclosure agreement versus when do you use a confidentiality agreement? In general, they're so close. Confidentiality is a little bit larger. Like I see it as everything is confidential, right? The non-disclosure is a little bit more nuanced. It kind of goes both ways, but I would say just stick with your NDA, but have it specific. You kind of want it to be specific to what you're talking about.
Gotcha.
A non-compete is different.
Right. Lucas just typed something that made me think. A lot of times when we're reading NDAs, what we look for is a non-compete clause in the NDA. That's a big red flag for us. Are there any other clauses that typically show up in NDAs to be careful of?
I was just going to say that. So the non-disclosure, the confidentiality, the non-compete, non-solicitation, I mean, those are all clauses at the same time. So once you sign an NDA, when you do engage in business, you will have that new agreement have a non-disclosure provision or a confidentiality certainty provision. So it kind of gets subsumed as you move forward. The NDA is really like, we're not sure if we're going to do business yet, but we want to make sure that what we tell you, you're not going to take from us and then not get into business with us.
Right.
Basically. So with the non-compete, it depends what state you're in, actually. In some states like California, the non-compete language is just interpreted to be not really enforceable, actually. So if it's an employer telling an employee or something like that type of relationship that you are not going to be able to compete or perform services for another person for a certain amount of time, those are seen to be non-enforceable. Again, California is a little bit higher in the non-enforceable around non-competes. So then you have almost like the corollary to the non-compete would be the non-solicitation. So that's where you're telling your other business company, we don't want you to solicit our employees, our independent contractors, our personnel. And those are a little bit more enforceable because you think of it, in general, the law wants things to be on parity. So if you have a big company and a small employer, especially in California, it probably won't be enforced.
Got it. Cool.
Does that help answer that question?
Yes. Are there any other states like that to keep that in mind for? That was another thing I had written down was we have a handful of clients that are out of state, and I'm in Texas, so sometimes we have contracts coming in from New York, from California, and I've heard the non-compete in California thing before. As far as, I guess, New York and Texas go, any other clauses specifically stick out as not really enforceable?
I'm licensed in California, Oregon, and Washington, and so in those 3 states, they kind of lean more towards California. New York, in general, my understanding is that it's not as strict as California. California is often seen, in general, you can assume that California is going to have the most stringent enforcement for consumer protection. Similarly, like employee protection. They're just really, they have a lot of public interest groups that are looking out for the best interests of consumers, especially if you have a product. Not quite as much with data and data services, although that's kind of, they're usually on the forefront. In general, Texas, New York, some of the southern states are going to be a little bit more favorable to businesses.
Cool.
Especially you can think of like Delaware is very, very favorable to businesses from a taxation standpoint and from an enforcement standpoint. I'm not an expert in every state, but that's generally how it would swing.
I'm going to jump to Seaton's question from earlier here real quick, and then I want to ask you afterwards about for different entities in different states. But Seton asked, have you ever worked with intellectual passport, and what are the pros and cons compared to a patent? And he said specifically for an encryption algorithm. And Seton, you can explain more if you want to explain any more on that question.
I mean, yeah, I have like 10 specific questions with that, but I mean, just generally speaking, I know an intellectual passport, from what I understand, is a copyright, but you can enforce it like a patent, and I've seen some pretty favorable stats on suits won, as well as the intellectual passport says it stretches across about 180 countries and is also private unless publicly disclosed, which is another reason I had some interest in it. And additionally, if you can, does a what do you call it? Notarized. Like if I'm about to go file an intellectual passport with my attorney in 2 weeks, and I notarize today the exact method I'm filing, is it enforceable up until the day I had it notarized, like some people led me to believe on the internet? If you know, I mean, I don't know.
I'll be honest with you. I'm not a patent expert. I license patents really well. So what I've found is that people that work in patent law, first of all, you have to be a patent attorney, which means you have to take a separate class, and take a separate test. In order to take that test, you also have to be, you have to have a sciences background, which I don't have.
Cool. Okay.
So that said, I've spent the first part of my career in biotech, so I've worked a lot with patents. I've particularly worked a lot with reading patents and then helping to figure out the best business strategy to make the most money and help protect them. Domestically, with patents, there's a time limit that's set on it. So you have about 20 years to really build your product. And the question is, when do you want to start that clock, and how are you going to build that as big as you can? I'm doing a little bit of reading right now on this intellectual passport. I could probably get back to you with that.
And the reason I ask is because what I read about it is that, of course, my patent attorney wants me to file a patent and says intellectual passport sucks because he wants the $50,000 in legal fees. But I read that intellectual passport could be competitive and easier, and it's like $10,000 to $15,000 to file, and it's private. So yeah, if you could, just your 2 cents would be much appreciated. Generally speaking.
I mean, I definitely want to get back into it. What I'll say to you is that I've never really heard about it, so I will look more into it.
Cool.
But given the fact that I've never heard of it, I can tell you right now that if you have something that's patentable, especially in the U.S., that's going to be giving you the biggest protection.
First period. Okay.
I don't know if you guys, how much does, I don't know, how do I ask this, Dimitri? Does everyone know about copyright, trademark, and patent, what we're talking about when I use those terms? Is everyone familiar with that? Okay.
I would assume to some extent, but if you could do a quick, maybe like 2 or 3 minute kind of overview on the Venn diagram of those, that would be great.
Yeah, so it's sort of more like in general, it's going to look more like this, where you have copyright. It's a right, and it is. Like from the moment that you make something or express it, you have it, and then there are different ways that you can use it. They ask you to register it with the Library of Congress, but that's a constitutional right that we all have. It's written in the Constitution, Article USC 17. Patents, so the copyright costs about $35 to register with the Library of Congress. Okay, patent can cost upwards of $50,000. It takes a long time, and you have to apply for it. That is going to give you the most amount of protection possible. If you have a patent, nobody else can use your product, or your process. But it depends, they say it depends on the 4 corners of the patent. So it's how you write your patent, which is why you want somebody who's specialized in the industry, that's going to really dictate. So patent wars, this stuff, happens all the time in big business. I worked at Adidas and I worked with Nike, and we're just going back and forth writing patents all the time, just trying to knock the competitor out of that space. So the space right now, to use that analogy, is wearable technology. So we're just trying to go as fast as we can and get as many patents as possible on biofeedback with temperature or heart rate, the threading, what it's made of, the composition. And if you can get that patent, that gives you more time to build out your product. But it's at that point, it's very competitive, and it's fast and furious. But most entrepreneurs don't have 50 grand to lay down like that. So you want to be kind of mindful. If you have an opportunity to get a patent, you probably should, in general. If it's something that you can build out with your product and your services, and you have a strategy around that, certainly that's the 50,000 that you put out is probably going to come back to you 5-10-fold if you can do
Can I
it
ask you
effectively.
a follow-up question on that note?
Sure.
Software, for example, I'm not super technically inclined. I know what I have because I'm working with people on it can be built into a software. If you had a method or a process that's used to build several different software programs, would you patent just the process and then include some about the programs or some types of programs, or would you actually, I mean, where do you draw the line there, if you can? I mean,
Yeah, again, this area is not my specialty, but
okay.
generally,
Yeah.
so what I would generally, I'll just say, process patents are going to be more difficult to obtain than a utility patent. So if you think about the gaming industry, people are constantly coming out with a new, like there was a joystick, and then there's like different types of interfaces or like a wand. That's what's patentable. Generally, just the underlying code or the process, it's more difficult to patent on it. So I hope that's somewhat helpful.
Yeah, that is. Yep.
You want to get something that's that has the highest chance of getting that patent, and then you want to have it kind of be as specific as possible, but broad enough that it knocks out some competitors.
Right.
Okay.
Very cool.
So in the middle of this somewhere is trademark, and so you can have all three. And most likely, when you're building your IP portfolio, you're going to want to have copyright, trademark, and if you can, patent protection. It's not one or the other. It's all. It's almost like if you're playing chess, you have like the pawns and the front do one thing and the knights and the rooks do something else. So the trademark is, that's a little bit more expensive. That's in the middle. It has more protection, right, than just copyright. So that costs around, in attorney's fees, typically $2,000, $1,750 to $2,000, and then to actually acquire the mark around $2,000. It's not that bad. It's not $50,000, but it's not $35,000. The purpose of a trademark is to reduce likelihood of confusion amongst consumers. And that, again, is not a right. That's something you need to apply for with the U.S. Patent and Trademark Office. The U.S. Patent and Trademark Office assumes that the reasonable consumer, the average consumer, is pretty dumb. So you really have to be careful and mindful when you apply for trademark protection that you're not unintentionally going to infringe on someone else's mark, because you could ask for a lawsuit and complications you probably don't want. Any questions on that? It's just general. Okay.
Well, I will dive into Luke's question on best practices about contracts. So what are the best practices around creating contracts regarding IP, such as consulting, strategic advising, and other intangible services?
Okay, consulting, strategic advising.
Yeah, and
other
services when I guess when we say intangible, sort of like consulting or strategic advising, something that's not like delivered in a visible way, I guess. And Luke, maybe you want to elaborate a little bit more on that.
Okay, so intellectual property, again, that's that intangible part. So you're talking about, so intellectual property, again, is copyrights, which is a bunch of different rights, trademark, and IP. So if you're doing consulting or strategic advising, I guess it kind of goes two ways, but I'll take it from the standpoint of the company. Are most of you companies, or are you the smaller kind of independent contractor who's giving advice to a company?
I think most of us at least have an LLC.
Yeah, there's a varying amount here. So I would say like on the scale, Luke is probably more on the independent contractor side as far as how he works with clients, and then Anthony and his company, a company with a larger team and a management structure side. So this question
so generally
more for coming from the independent contractor side, but if you could answer somewhere on that range, that would be awesome.
Okay, so I'm going to tell a little story. So generally, there's a big company and you engage with somebody, and it's usually an employee-employer relationship. That means that the employer is going to pay the taxes and sort of like a bunch of it's more expensive to have an employee. So some people just want to have an independent contractor. Generally speaking, with an independent contractor, the IRS has a number of criteria to determine. Even if you call someone an independent contractor, they have like 21 different criteria, and none of them are more important than the others. So it's just kind of like a feel it out kind of a thing. But you want to think about, does this independent contractor provide services for anyone else? If they only provide services for that one company, they'll be deemed an employee, right? They have that relationship. Other things are they using their own machinery? So are you providing them with a computer? Are you telling them what to do? Do you direct them? Kind of thing. So the point here is if you want someone to be an independent contractor, be really mindful of that, right? An independent contractor owns their intellectual property as a matter of law, unless you call them a work for hire agreement. And then the employer, and then the employer would own that intellectual property. So if you think about it in the context of IT consulting, and you have a technology advisor who's an intellectual, who's a consultant, you want them to be under a work for hire agreement because the company wants to own whatever it is that they're consulting on, the IP.
Hey, Melissa, can you hear me?
Yeah. Yes.
Sorry if it's a little ambient. We're in a coffee shop right now. So for things like IT, where you're providing consulting on a specific deliverable, as in, you've got some back-end coding, you've got some sort of program, whatever it is, I see that. What about the intangible stuff? Like what I did was provide marketing strategy, business model creation, basically the intangibles associated with the marketing side of things for one company, but
Can you repeat this question, because I can't hear it?
Sorry. Basically just intangible services. Like there's no end deliverable besides the result, besides the consulting, besides the it's all in their head. It's all in the advice space. It was something where I dealt with a few legal issues about ownership of what I created, or ownership of ideas and marketing plans, and how much contact I had with the clients. So it sounds a little confusing, but that's kind of why I'm asking the question, because a lot of what I do is very cerebral. It's very high-level strategic type stuff without any specific deliverable, if that makes sense.
So Melissa, I guess in this case, so Luke is the contractor. Let's say, so we have a contractor. How does that contractor, as a consultant who creates, let's say, marketing plans or strategy, product launch plans, so on and so forth, for other companies, how does he what are some of the best practices he should have in framing his contracts with his clients?
Okay, so you want to keep in mind that IP is valuable, even though it's intangible, right? So just given that framework that as an employer-employee relationship, the employer will own the IP. An independent contractor relationship, the independent contractor owns it unless it's a work-for-hire agreement. And so even if you say in the contract, this is a work-for-hire agreement, then you probably want to follow that up with some other language that says even if a trier of fact doesn't find that this isn't a work-for-hire agreement, the independent contractor assigns and transfers all right, title, and interest to any intellectual property that is generated. Basically, that's going to cover you as the employer. The independent contractor, to answer this question, Lucas, you just want to be really mindful of what you're engaging in, right? And so who owns that IP at the end of the day? You might want to get a little bit more money. So that's just a conversation. It's a negotiation, right? Who owns what and what are you getting? If you're going to buy hours of your time, then they get hours of your time, but then you should hold on to that IP at the end. If the understanding is that the whole purpose is that they're going to own that IP, make sure that your rates reflect that. Because at the end of the day, if somebody messes up and forgets to put that in there, you will have a claim. Whether you decide to pursue it or not is up to you, but we're just talking about where the rights fall. Does that help?
Yeah, I think for me the pain point in this, and I'm sorry again for the ambient noise, the pain point was in dealing with the repercussions of taking.
I can't hear you, so I'm going to let Dimitri ask to see if I can.
All right, I'll type it in.
Yeah, that would be best. Yeah, if you type it in. I mean, while Luke's typing that up, any other specific questions?
Yeah, I do have one on this particular topic. One of the things that we've been doing a lot with these, like with the relationship with contractors and developers overseas and things like that, developers specifically domestically, is empowering them to start their own LLC so they can write off their own expenses instead of hiring them on as a contractor. So I guess my question is, like, what is the default state of like two entities doing business together? I know you said with a contractor, the contractor keeps intellectual property. What's the case with two LLCs engaging in consulting or work for hire?
What was it? I can hear you, Melissa. Your screen gone black.
I couldn't hear that. I mean, I got some of it, but I couldn't hear all of it. I don't know what's going on with the connection.
Yeah, let me just repeat the question. Basically, I've been empowering a lot of people that I work with domestically to create their own LLCs
Yes.
so that they can save on expenses, and so that I can avoid filing 1099s. It just makes everyone's life easier. In that relationship, what's the default state there? Is who owns the intellectual property?
Got it.
You know what I mean?
Yeah, totally. So this kind of relates back to, in a way, one of Anthony's points, which is what are the standard provisions in the contracts that you'll look at. So for you, Austin, you're going to be really, really clear, and you're going to have an intellectual property provision, and it's going to state that your intellectual property is yours and that nothing that you engage in with any other LLC is going to amount to a partnership. They're not going to be able to use your property, your logo, your trademark, your name, algorithms that you provide to them outside of how you ask for it in that contract. And any additional services would be owned as they would be considered a work for hire, and that you would own all of the intellectual property. presumptively. Okay, because it doesn't matter if it's an individual or an LLC. You're always going to want to be really clear on that. And as you continue to build your brands and you have a trademark or a recognizable name, you want everybody to understand that they can't just use it. So case in point, if you contract with an LLC and then they start writing on their website and put your logo on their website to show that they've done work for you, again, so you want to make sure they don't necessarily have that right, or that there's some sort of consideration for it. So that's just one example. Maybe that's not how you want to run your business and you don't have to, but that's your right. That you can prevent other people from using your name, image, logo, whatever it is, without some compensation. It's just another way to keep an eye on the ball of what your intangible assets are and how are you leveraging them, right? That might be a small one, but maybe you don't want everyone to know that someone else wrote all your algorithms. Like you just have to think about it from a strategy standpoint. Like, do you care? Maybe you want to put that in the agreement, like, hey, you can go ahead and use this, and maybe that's like a little negotiation tactic. It's kind of good faith, and maybe you can get a discount on services or maintenance fees or whatever else it is. But just kind of thinking about how, once again, you're using what you're putting your blood, sweat, and tears and money into to, get the best result for you.
Got it.
Could you hear me on that? Okay. Yeah.
I'm going to rephrase part of Luke's question here, and it's, I guess, more importantly, regarding damages. Let's say several people here have a services company. Let's say you provide services for somebody, and that they're not happy with the services. What is that person's options to the range of, let's say can the client sue you for some sort of damages let's say you build websites, or let's say you do something, you write copy, and part of the copy that you wrote resulted in, some issue going on with the client or their clients or whatever the service is. Let's say the company claims that the services you provided either were incomplete or created some sort of damages. What yeah, how is that protected against in that contract previously, and if it isn't protected against it?
How can you minimize that?
Yeah, let's say if there is no contract, what's the extent to which that can go?
So you can, in your contract, be as specific as you want. That's called a disclaimer, right? Like, there are no guarantees. Like, I'm giving you what I'm giving you, and this is all subjective. And usually disclaimers you want to put in bold, capital, and underline, right? Like, there's something called, well, typically more in products, a warranty of merchantability, meaning that if it were a product that a normal, reasonable consumer could use it in a normal, reasonable way and expect a normal outcome, right? With services, it's not like that. It's more subjective. So you could just write, like, in really big, bold letters, there are no guarantees. That's one way to do it. Otherwise, the default is that there's a pro rata payment. So if you only provided services for like 2/3 of what you said you were going to do, maybe somebody could sue you, and then generally the court wants to pay you for your time and what you've actually produced, but they don't want to give you everything. So if you take a step back and you don't have a contract, or you have a really crappy contract that isn't very specific with your scope of work, including deadlines, what you're going to do, when you're going to do it, what is it going to look like for your employer or your company, that becomes a really gray area that a trier of fact would have to interpret and would have to try to figure out what was the agreement. The more clarity that you can provide, as even if you need to chunk it out into phases. In phase 1, I will review your I will give you a 3-hour consultation and review your current business structure. as long as you do that 3-hour consultation, you've provided the services pursuant to the agreement, and there should be some exchange for that. If you're kind of sloppy on that end and you don't have it really clear, that's where you can get into some. It depends who you're working with, but you could get into some kind of BS litigation, because then somebody can say, well, on this phone call you said you were going to do this, or my impression was that you were going to do this, and it gets a lot messier and more time consuming. Does that help?
Yeah, I just want to add to that question. Can you hear me?
Yeah.
So, do you think a good way around that is maybe having a terms of service where I kind of like specify everything that we do, and then I can improve it and build it upon as I learn about my business, what I do, and then every time I enroll with a new client, they just go ahead and if they are paying me, they are agreeing with the terms of service. Then if they come back and complain, they have nothing to do or nothing to sue me or nothing to be damaged or whatever because they agree with that thing.
Yeah, so that's kind of two questions that I hear in one. One of them is, as you're setting up a true agreement, a contract is going to have two parties signing it. So both people will agree. That's called the meeting of the minds. And so if you're going to structure the agreement, what I typically do is have what's called boilerplate language, what's going to be the same for every single client that you work with. Your confidentiality provision, your intellectual property stipulations, your agreement not to solicit or your non-solicitation clause, maybe an indemnification, some other, things that should probably go in there. Certainly, choice of law. It's called boilerplate language. And then you're going to be really specific on the attachment or Exhibit A, which is going to have your scope of work. And that's going to be between you and that client. And what are you doing for them? When is it due? How much are you getting paid? Really clear. Payment terms, by the way, are typically in the body of the agreement, not in the attachment. So you're always going to get paid however you're going to get paid, by check, by wire transfer, whatever method you use. And you're going to have the same accounting that you always use for all your clients, 30 days, 90 days, 60 days, 15 days, whatever it is. But that scope of services is going to be more specific to what it is you're doing for that client. I like to structure my agreements that way. I think it makes sense because then you can have the same client and just update it with your agreement with an amendment that has an Exhibit B, which may be like another scope of services, or Exhibit C. You don't have to go through the 7 or 10-page agreement every time. You can put a one-pager in. What you were just asking about could also be interpreted as terms and conditions. So that's more like if you're online and you see click-throughs and you see the terms and conditions. So there's no meeting of the minds per se. It's like if you work with us, you agree to how we work. That's the terms and conditions. There's no negotiation. There's no changing any terms. That's where you see things online. There's a little click box that says you agree, and then payment. So that's where you have sort of the meeting of the minds, and then that other big portion, the payment portion, is called consideration. So once you get consideration and an agreement, you have a binding contract. There's offer, acceptance, and consideration.
Now, do you think, with that being said, like for us, if we're just specifically offering services, but we want to facilitate all of this, because definitely we don't want to go through all the hassle every time, and if it's more of a $100,000 kind of web application that we're building, yeah, of course you need to hire a lawyer to write all the contract. But if you're just doing like independent contractor kind of deals or small size jobs, what I've been doing is setting up this monthly retainer clients, and I'm just trying to find a way that this is, as you said, this is the way we work. If you are going to subscribe to our membership, you're going to get access to all of the services. These are the terms. That's it. Period. Will that help, or do I have to go and provide to every client a specific contract?
if you have terms and conditions and you decide that you're not going to change those terms and conditions for anyone, and if you're going to work with me, this is how you work. That's it. Especially if you can do something like that online, where somebody can click and it's yes or no. There's nothing wrong with that. That's a binding agreement. Like I said, I usually like to tie that with a payment. You definitely want to make sure there's a checkbox or maybe even initialization so that people can initial, yes, I read and understand and agree, right? Those three keys: read, understand, and agree to the terms and conditions. That way, I like that if you're going to do a high volume of the same type of service, because if someone comes back and says, well, you didn't do this, you said you'd do this, but you didn't, you can say, we only do it one way. This is how we work. This is how all of our clients work. That's called standard business practice for your specific business. And that has a lot of weight if you were to go into a court of law. If you just say, this is how we do it with everyone, we never change, that's going to be a pretty high bar for someone else to say that you agreed to change it and didn't perform on that.
Great. Thank you.
How do you put those standard business processes in place? Is that part of a contract, or how does that get conveyed?
So that's one of the things. Sorry, go ahead.
You're good. I think you're just a bit delayed, but we can hear you.
I'm having trouble hearing everyone. Hopefully you can hear me. Dimitri, can you say that? Can you try it again?
Are you on your phone or computer? If you try, maybe if you try hopping on.
It's an iPad. It's an iPad.
Did you hear my question?
What was the question? How do you put those into place?
Yes.
Is that essentially the question? Okay.
Yeah.
So that's one of the things that I specialize in. I like to be really intentional and understand what it is you do and how you work. And if you're working with, I think, a good business lawyer, you're going to have somebody who's going to ask you questions and push on you, because that's where you're going to get the answers to what your process is, and that's going to make a really strong contract or terms and conditions or policies. There's no right way to do business, right? This is where the holistic part comes in for me. It's what works for you. And so as long as you understand what the issues are, and you can have somebody ask you questions like, well, what if this? What if, what if you have an independent contractor who's overseas and they're providing a substantial amount of intellectual property? Like, just thinking through some of the issues, then you're going to have a very solid agreement, whether it's in the form of terms and conditions or an actual contract. And quite frankly, I think that those policies and practices come about through experience sometimes. And so it's the ability to have somebody that you can throw questions to. This opportunity came up, we're interested in it, but we have some concerns. Then you're going to have a more robust understanding of how you operate as a business and what your policies are.
Melissa, do you have I know usually when I would look for like a legal template, I would just literally go into Google, type in the name of the template, and just find stuff, and sometimes I would find it for free, sometimes I would buy stuff. Do you have like a recommended resource for most legal templates, especially for services contracts?
I don't, because exactly what I was just saying. I've worked with a lot of clients who have got big and small, who've really kind of gotten screwed because they didn't know what was in their contract, or how they worked wasn't reflective in their contract. So the things you want to think about are, you're the expert of whatever it is you're doing, whether you're selling services or products. So how do you work? What is your turnaround time? How long do you need? What information do you need in order to do your business, and what format do you want it in? just basic stuff about being really clear about how that works. Payments, are you invoicing or do you take payment up front? If you're going to have a monthly subscriber, how are you going to take those payments? And what if something happens with the card? Maybe it expires or it's lost and they forget to update it. Do you stop your services? Or if not, do you give it a 30-day lapse and try and contact them? How do you try to contact them? Just these questions about what are you going to do, and once you have that hammered out, you follow it basically, and try not to deviate too much between all of your clients, because that's when you can also get confused. Like, what did we agree to? And then you have to find the agreement and then go back and read it, and then you might realize, shit, like we messed up.
So where do those processes get published? Do you like put that on your website somewhere, or how do they get put in place?
It's a really good question.
The last thing we heard you say was that's a really good question.
I can't hear you. Okay, so what I heard of that question is, where do you put that? So I like to do a few things. First of all, anyone who's doing anything online, you have to have a privacy policy, right? So that you just have to make sure that you have an updated privacy policy. I don't care if you look at other Google or Facebook or whoever you want to look at, Adidas, read their privacy policy, but you have to have one if you're doing business online. The next thing is, make it applicable to what you're doing. But that's not, the privacy policy won't change. It's just you have to be compliant with a few of the statutes, and they're all kind of going to be the same. I like to have all of my clients have policy book, or whatever, or, just policies in general. And then you can update that from time to time. And you can also put that on your website. And the reason I like to do that is because I like to sneak into my agreements a promise that they will adhere to all the policies as updated from time to time. Okay, so that means that you can sort of sneak in some language that hadn't occurred to you earlier, right, to some extent, in the policies after you've already signed your agreement. So that kind of gives you like a way to backdoor some things.
Smart. So instead of, let's say, for late payment in the contract writing, we have a 3% per week fee for that. We could
or is updated from time to
our
time.
latest late payment policy, which is always published on our website and updated. That's awesome. Cool.
Thanks. Yeah. And everyone does it. That's not sneaky. That's just kind of standard, especially when you talk about, I don't know if any of you have employees, but that's the employment handbook. Those things are updated from time to time, oftentimes when there's a problem or someone needs to leave, so you just get really clear.
Yeah, so instead of saying you will follow everything in this contract that you're signing now, one of the clauses, you will follow everything in our policies, which are updated on our website. You can update the policies on the website. Question there, do you have to? So I know I get like emails, for example, from hosting companies saying, hey, we've updated our privacy policy, read this section, or I get that from PayPal. Do you have to send that out to all your clients and your employees, or is that just is that an optional thing that you would do to just provide a better service?
Well, two things. Just to slow it down a little bit, I would make sure that whoever is signing the agreement, the language would be that they agree to check the policies. So first of all, they want to read, understand, and agree to the policies as provided, and also agree to read updated policies as provided from time to time. So that puts them onto some, like, there's a little hook. So they have an obligation to look, which no one does, none of us do. But it doesn't hurt to update every so often, send something out to your clients or independent contractors or other entities, Austin, we've updated our policies, check it out. Here's a link. And then if they do, they do. If they don't, that's fine too. You've kind of checked that box on your own.
Got it. Awesome.
Sweet. Are there any other questions about terms and conditions and whatnot and policies? Because I have some questions about entities if everyone's ready to move on to that.
Let's go with an entity question. We don't have too much time left, but yeah, let's do that.
Awesome. So my question is mainly about nesting entities. Like right now, I have a different entity for each kind of arm of my business, one for consulting, one for the hosting company. And I'm just trying to figure out how I should nest the entities as far as like how much ownership each company has in one another, mainly to optimize for minimizing tax liability. Because I know that like some of the ways that you structure your corporations could be maximum privacy or maximum legal protection. My interest is saving as much money on taxes as possible. So is it how do I nest those corporations, and what's more advantageous from a tax perspective? An LLC or an S corp.
Well, that's a very loaded question, and I could probably talk to you about that in specific for a while. If you're talking, I don't know how much money you're bringing in and what your tax liability is right now, but in general, the best way to reduce your tax liability is to offshore your company and to not have a U.S. entity. I don't know if that's what you're talking about, or and I do that with clients all the time. I mean, it just makes more sense to be in another country. So if that's what you want to do, then you want to think about where you're going to be and what kind of protections are offered, and it can get a little complicated. It just depends. It just depends on a number of things that you are looking for. You can always have an offshore entity hold domestic entities, and that also can get a little complicated as far as if there is an action brought against you by the IRS or others. Like, at what point are you kind of
Got it. Yeah, because even if
able to be garnered or not.
Because even if you have an international corporation, you still have to pay taxes on any, like as a U.S. citizen, you have to pay taxes on anything you make outside of the U.S., right?
Well, it depends. It depends. If you are domiciled in the U.S., if you live in the U.S., and that's your primary residency, then yes. If it's not, then no, which is the same with most countries.
Got it.
So,
cool. So
yeah,
what I'm
even
getting
if you're
from
a
your
UK
question
citizen
is that,
something else.
like, what I'm getting from your question, or what I'm getting from your answer is that, it's a really case-by-case basis, and once you hit a certain point of revenue or growth, it makes sense to just sit down and have someone such as yourself just kind of, talk to you about your goals and then structure everything for you.
Yeah, and you can do that at any time. It's not necessarily tied to money, but I think it's a really good idea to be mindful of that, certainly. But to answer the other part of your question, since you have kind of like a number of LLCs and you're wondering, is it better to stay in LLC or an S corporation? It depends. Typically, I say around like $150,000. It's usually better, I think, to switch over into an S corporation. So I'm not an accountant and I'm not a tax expert, so I don't give tax advice.
Mm-hmm.
But as an S corporation, you can kind of you can take, well, first of all, you can set your own income. So it depends how you set that income. If you're making less than that threshold amount, you may be taking, you can sort of offset some of your assets or your income against what you haven't been able to pay yourself. So you can take a loss, right? So that's a tax savings kind of option with an S corporation. Also, with an S corporation, they say it's pass-through taxation, but you know, you can, and then this is kind of, I think Austin and I talked to you about this before. You can do it with just general entities. So if you have a bunch of LLCs, you can have like an operating company and an IP holding company, for example, or another holding company that runs all your finances, right? So that's one way to minimize your taxation, because those two entities, the operating company, the one that's actually doing the service, and the holding company, the one that's running the money, are going to engage with each other in a contract. And so even though you're kind of doing the same business, there's going to be a bottom line write-off, because you're going to have to pay your holding company a certain amount of money. So if you're really strategic with your IP and you have an IP holding company, that means that you have to pay your IP holding company $15,000, $25,000, $250,000 a year if you get bigger, just for the right to use your own name and logos or copyrights,
Right.
or patents. Right. So if you're bringing in that revenue as the operating company, then you're deferring that income to another entity whose income is going to be contained to a lower amount. So you're kind of shearing off, and most companies do this. I like to create, and of course I'm an IP lawyer, so I always like to create an IP holding company, because if you ever sell a company, anyone that you do business with in the future is going to be tied to those contracts that you set up initially. So they will have to pay you, your IP holding company, money to use the name that everyone recognizes. Does that make sense?
Right, that makes sense. It also
So
makes sense
ongoing
to
income.
but it also makes sense to like compartmentalize like that in the event of a sale, because then you can sell only certain aspects of your company versus others. Am I right?
Yeah.
Okay.
Yes, that's true. And then especially like just to keep it simple. So yes, that's very, very true. And and especially with the intellectual property, if you think about it, a shoe is a shoe is a shoe, but people will pay a lot more for Nikes, or if anybody was at Traffic and Conversion, for you know, Timberline boots or whatever. It's the name, right? It's the brand, and that's kind of what you are all doing too, is you're building a brand. So your customer is going to identify with your brand and stay loyal to that brand, which is going to be more you know, more money, essentially, at the end of the day, if you hold on to that. You can sell it separately or license it.
Awesome. Thank you.
Sorry, I couldn't answer your main question more. It's just too complicated.
No, it's
unless
okay.
I know
there's
what
so
you're dealing
many.
with and what state you're in.
Yeah, I know there's so many variables involved, but I think I'll just sit down with you here in like a month or two, and we can restructure everything.
Nice. So I guess the last thing that I'll just offer is I've been offering a small, I don't know if it's called a mastermind, but a small group offering to about 4 or 5 people, if anyone's interested, to continue to have these kinds of talks as opportunities come up. I think that's the best way to really learn about the law, is when you're looking at real life circumstances. You kind of has some context for you. It's not just theoretical. And then when you're listening to other people that you know, like, and trust, and what they're going through, it's going to inspire your own business. So I'm offering that group. If anyone's interested, you can just let me know.
Cool.
Awesome.
Yep. Yeah.
Cool. Well, Melissa, thank you so much. This has been really awesome. I think we got a lot of really good questions answered. I know I learned a lot and quite a few things that I'm going to do differently after this, and I'll publish my notes as soon as I have them ready. Like that policy thing was really awesome, as well as a few other key points that I have of things I'm going to change in my own company. So yeah, thank you so much for your time. Really, really appreciate it. Guys, if you have any follow-up questions that come from this, I mean, post on Facebook and kind of feel free to continue the conversation in that thread.
Sounds good. Well, thanks, guys.
Thanks so much, Melissa.
Thank you, Melissa. Thank you.
Thank you.
Bye-bye.
Bye.
Bye, everyone.